So legatee or devisee, as amended, is movable or immovable beneficiary. Legatee and devisee is movable and immovable beneficiary. You just reverse the word immovable with movable, then the correction will be made. This wording confusion only appear in the English version, and it only appears to be confusing when you are using the specified form, and when there are in existence either one or both types of property. Strictly speaking, it makes no much sense in terms of difference, in terms of priority, except that in order to fulfill the specified form by strict adherence to the qualification on assets, you will have to be very careful to look at the estate to see whether the contents of the estate comprise of both or just either one of the two. When we say this, we refer to assets held immediately by the deceased. Well, we may qualify to say it also includes held by some third party as trustee for the deceased. There is a difference if this is held under an intermediate hierarchy of a corporate vehicle. So, if the deceased purchase a property and have it held through a limited company, whereas the deceased in fact own part or all the shares in the limited company, and the limited company holds the immovable property, then in our grant application we will have to make a choice and say that, well, there is only, I'm just applying as a legatee because the asset consists only of movable assets. Consists of movable assets. Because in terms of the company vehicle, what the deceased held was only the shares in the limited company. One don't just, remove the corporate veil to see, in fact there is something, it only held limited property. So one deceased, 100% shareholder, holding a limited company, and the limited company holds nothing but a landed property. Still, this is only a movable asset for the purpose of inheritance. Then, in our specified form, the default choice is legatee or devisee. But then, in our actual choice, this default position must be wrong. So you can only choose legatee, devisee, legatee and devisee. These three are correct options. You cannot say, what is the capacity of the grant applicant? I am a legatee or devisee of the estate of the deceased. Then you're wrong. although this is a default position in the specified form. I think the class is now almost an expert now in terms of the beneficiary who is having an absolute interest and a beneficiary who is not. On the one hand, on intestate, you have already looked at the contingency entitlement of the child and issue, contingent on attaining the age of majority. When it comes to testate situation, then we may have various disposition provisions under the will, particularly when there may be life tenant, and then there is a give over of the remainder. This is one usual way. Or another way is a gift upon attaining certain age. This last example is uncertain. It is uncertain because it depends on the wordings. Sometimes the wordings make it a conditional gift. I will give you a share of my residual estate conditional upon your surviving me, or conditional upon your attaining 30 years of age. Then the actual wordings will have to be scrutinized very carefully, because it may be argued that, well, what happens if I die at the age of 29? Then if this is a strict requirement, then you die before the conditions are satisfied. You die before, let's say, you survive 28 days after the death of the testator. So these are absolute requirements. So you don't survive for 28 days. You die at, let's say, on the 27th day. By analogy, if the gift to you is given only when you attain the age of 30, when you never made it. The further complication is, well, if you never make it, then is there any terms under the will similar to the first provision on intestate? Or further still, as we first put it, was it just something contingent, and the contingency you never satisfy? So all these are very important in order to decide whether the beneficiary has or has not got an absolute interest. Now, this understanding is slightly different from another term which is called accretion beneficiary. In this slide, we are talking about absolute or qualified benefit. Accretion beneficiary refers to something different. It means, well, you don't have a present right. You have a right if there is any increase in the size of the estate. So these are the stuff that we have to bear in mind. And a further complication is, well, whereas you may have an absolute interest, but then your absolute interest may be qualified and may render that you will lose your benefit in terms of inheritance. This we refer to the Hotspot Rule. The Hotspot Rule is a rule against double benefit in terms of those possible affecting the surviving spouse. Usually it will only affect to the maximum of the statutory legacy, meaning $500,000 or $1 million, as the case may be. But when it comes to other beneficiaries, there is a possibility of the three different Hotspot rules, either inter vivos on children, or testate, or foreign domicile. Foreign domicile intestate entitlement. Or I correct myself, it's not foreign domicile intestate, it's foreign intestate. It's foreign intestate. When we talk about Cap 73, usually is Hong Kong domicile. So all these three Hotspot rules, insofar as it affects the next of kin, other than the surviving spouse, what you may have in terms of as an absolute beneficiary may render by reason of the Hotspot rule, render that your entitlement to inherit under the rule of intestacy to be reduced in the maximum situation so that you have zero benefits. So these are the various stuff that will affect us in terms of the entitlement. And when we bear in mind that we're talking about grant, if you're next of kin without beneficial interest, by virtue of the various reasons that we have just cited, then you may not be able to qualify and satisfy this terminology as a next of kin with beneficial interest. If you don't have beneficial interest, then you don't have no priority to apply under Cap Rule 21. Then, when it comes to grant application, when there is a will, there are other matters that we have to bear in mind. First of all, the term testate. I think most of the situation when we talk about testate, we mean a person died with a will. The only possible difference is on testamentary expenses when it comes to who is entitled to pay the expenses when even on an insolvent estate. These testamentary expenses have been given a wider meaning to mean administration expenses. Administration expenses will therefore include normally funeral expenses, cremation, application for grant, as well as the more traditional meaning when you die with a will. And then will, the term will is to be taken as to mean any will within the meaning of the wills ordinance, so it may mean a will. It will include mutual will. It would include mirror wills. It would include joint wills. It would include codicil. All these are various facets of different types of testamentary tools or document relating to testamentary disposition. All the examples that I've just cited to you, they are wills. They are wills. Mutual wills are wills made by two people of similar or same meaning, so that on an amendment of one, sometimes you will be contract bound, not being able to amend freely. This is mutual will. Mirror will is similar when two people, usually couples, make a will of similar or same content, but their intention is just to make testamentary disposition, which happens to be the same. There is no binding effect. Husband makes his own will, wife makes her own will. There is no binding effect. I can always change it. Joint will is more complicated. Joint will is something not so frequent. It's just two persons, A and B. They make their two wills in the same will, in the same document. This sometimes happen in those homemade will. When we die, we like to give our property to our son and our daughter, blah, blah, blah. So this is a joint will. So it is a will of the husband as well as it is a will of the wife. It's just two different sets of wills contained in one document, which is called the joint will, signed by both testator and testatrix, and to be witnessed by two attesting witnesses, or rather informally, needs to be proved under Section 5, subsection 2 of the Wills Ordinance. And the effect of joint will is this: after the first proof, if probate is granted, then on the second death, you have to prove again. So the husband and wife make a joint will. Husband died first, so therefore the joint will is being applied for as probate for the husband. And then subsequently, when the wife died, then that joint will, probate of which will have to be applied for again as probate of the last will of the wife. So this is joint will. Then will and codicil. Codicil, you can always make supplemental will. So then when you make a will, day two, you make slight amendments to the will by saying that I give my pen to A. You make this first codicil. You did not revoke the first will. So the last will is comprised of the will and the first codicil. Okay, day three, you make a second codicil. Now I give an apple to B. So when you eventually die, the last will of the testator will comprise of A, the will, then the first codicil, and the second codicil. All three documents will form the last will of the testator. As I said, in Hong Kong, this is not preferred and not popular. It makes the whole thing fairly complicated in terms of application for grant, and it is open up to all kinds of legal fights. It's much better that you revoke the will and make another one. It's better understood and it's cheaper. Will dispose of the whole estate. This is usually the case. Now, having said this, will dispose of the whole of the estate may be one thing, and then you make a will dispose of all your property in Hong Kong, then this is a limited will that deals with all the property, but it's still a limited will. And then you make another will, dispose of your cubicle, your flat, only. I give my flat to my girlfriend. Then this is a will, then this is a limited will, limited to one property, as different from the example that we have just said, is limited to property in Hong Kong. Then, Rule 19 provides for some further scenario. Will dispose of substantially the whole of the estate. Item 3 is will dispose of the whole of the estate. Item 4 is will dispose of substantially the whole of the estate. These are various provisions, as we shall see later on. Under Rule 19, then it provides for the priority of different members under different types of will and under different types of gift in order to decide who is having a higher priority. So you go from priority number 1 to priority number 5 and 6, etc. And wills that deals with the whole of the property, very simple. I give all my estate to my wife. But then this is item 3. But then in item 4, I give $50,000 to my father and I die. Nothing else. Informal will, no executor. Then I die. Then we say Mr. Wong died testate. He died with a will that disposed only of $50,000. Full stop. We don't know whether Mr. Wong has disposed of the whole of the estate. So if I die, as it turned out that I have only $50,000, then item 3 applied. Or when I die, in the same will that I give $50,000 to my parent, then it happens that I have, in terms of my residual estate, only amount to $50,001. Then item 4 shall apply, meaning will dispose of substantially the whole of the estate as compared at the time when the grant application is made. So when I make a will of $50,000, by the time when I make my will, I don't know whether this is item 3 or item 4 or just item 2. You look at it by reference to item 3 and 4 at the time when the grant is made. And then you compare under Rule 19 to see what kind of priority that may be. Item 5, residue not wholly disposed of by the will. There are various situations that may give rise to item 5. Residue not wholly disposed of by the will. Now, this term residue is very loose. It's very loose. One doesn't know that whether this means residual estate or not. It's kind of confusing. It's never sure. But we would rather prefer to mean the residual estate. So residual estate not wholly disposed of by the will. If I make a will, I give my cubicle to my wife. Full stop. I have $1,000 as management deposit, which I have not dealt with. So, in my will, item 5 shall apply. residue not wholly disposed of by the will. In a situation like this, then you have to argue within Rule 19, well, what kind of priority do I stand in terms of the applicant as a beneficiary? Whether it is a situation residue not wholly disposed of by the will, or whether this is a will dispose of substantially the whole of the estate. These are the situations sometimes make it arguable and sometimes give rise to the fight between people who have similar priority or people with equal priority, as we shall see. Wholly intestate. Okay, still back to number 5. Another situation may result in item 5 is affected by the doctrine of lapse. Residual estate somehow affected by the doctrine of lapse for the various reasons that we have already discussed. Wholly intestate, the same doctrine may apply. I make a will. I give everything to my siblings, and then I ask the spouse of my siblings as the attesting witnesses. So, Mr. Wong did die testate, but then all the gifts in the will are affected by the doctrine of lapse, avoidance of gift to the spouse or to the attesting witness. So no valid gift, but there is a valid will. So Rule 19 may still apply because it applies to a testate situation. It applies to the testate situation. So Mr. Wong died with a will, and there may be a nomination of an executor, but all the gift under the will fails to take effect. The executor will then be given probate by the probate registry, and then the gift will be devolved according to the rule of intestacy. These are the various situations which we will see as complicating factors under Rule 19. Non-residuary gift. So this is the chance for us to refresh our memory. So this is a concept I gave to the class when we talk about the doctrine of lapse. This is also related to the doctrine of redemption and the doctrine of abatement. Non-residuary gift, okay. That may include legacy, that may include device, meaning specific legacy, meaning specific device, and also that may also include personal capitals, that may also include, well, unidentified specific gifts. They are non-residual gifts. Then there is a residual gift. Remember, we are talking about grant, and we are talking about under the context of Rule 19, testate situation. So the previous slide, non-residual gift. If they are non-residual gift, under Rule 19, they are normally referred to as specific beneficiary. Specific beneficiary. They have the list of at the bottom in terms of priority for grant. Then when it comes to residuary estate, residual estate, we have to understand them in the context of testate grant application. They are not number one priority because they are not executor. Then we have these various types of residual beneficiary. Either residual beneficiary holding in trust. I make a will. I appoint him as the executor and trustee of my will, and then I go on and make description of provision for who are the beneficiaries, residual beneficiaries. But then I name him as the executor and trustee of my estate. So he is, at the one hand, the executor, who is number one priority, and then he is also a trustee of the residual estate. Even though in the will, my wording is, I appoint him as the executor and trustee of my will. This is a usual provision or appointment clause. When we say it like this, what I intend to say, and the legal effect, is that he is having at the same time, one, as executor, two, as residual estate beneficiary, holding in trust. I give him everything, and I name him as executor, and I also appoint him as a trustee. When I say trustee, in respect of all my estate, that must include all the residual estate. But as trustee, so I don't, by that nomination, I don't give him nothing as an absolute residual beneficiary. So what he is only a trustee. So I give him everything to hold for my son and my daughter. Then he is the executor, and he is also the residual estate beneficiary, holding as trustee for my son and for my daughter. So he is this residual beneficiary holding in trust. Then we'll have the residual beneficiary for life. I give my flat to my father. So I say I allow my father to live in the flat until he dies. And thereafter, I give the remainder to my wife. So my father is it not a residual beneficiary for life? Question. I want you to answer this question. Is he or is he not a residual estate for life? Okay, those in favor, please raise your hand. Please raise your hand. Yes or no? Only one hand, two hands. Those not in favor, please raise your hand. Not in favor. So either you're all wrong or you guys have no hands. Now, in a gift like this, under testate situation, we will have to be very careful. Because in the example which I just now illustrated, I just now raised it, it's very easy for you to fall into the trap. You say, oh yes, he is a beneficiary for life. He is a beneficiary for life. But this is wrong. The fact that this is wrong because I only give him the flat for him to live in. A flat is a non-residual gift. So in other words, What my father is never a residuary beneficiary for life, but rather my father is a non-residuary gift for life, or a specific gift in terms of the cubicle. He is only a specific beneficiary for life. If he is a specific beneficiary for life, his priority is same as the specific beneficiary. In other words, he is at the bottom of the list by virtue of the fact that he is not a residuary beneficiary. Got it? That's why I mentioned to you Rule 19 is very difficult and it's very confusing. So be very careful. And it's much better you make a will. You appoint someone as the executor. The kind of problem that we have just encountered can be best avoided. Then we have the final residuary legatee or devisee. Using the example that I've just illustrated, I appoint him as the executor and trustee of my estate for my son and for my daughter. Then my son and my daughter in this example is item 3. They are the ultimate residuary beneficiary. Alright? So I hope I have explained to you clear enough on this possible confusion. Then, executor and trustee. We have mentioned this before. For those of you who have attended class, you should be able to remember by now. Now, trustee and executor and trustee again are two legal terms capable of very different in meaning. The confusion lies in the fact that you may appoint the same person in one capacity, then at different stages in terms of the estate administration, the capacity changes from executor to that of trustee. The legal battle can only be solved as and when an assent is executed. A-S-S-E-N-T. But assent is executed normally only in respect of landed property. By way of assent of movable assets, chattels, assent need not be done in writing. This can be done by way of practice. This can be done by way of changing hands, by way of informal acts. So you will have to be careful. Now, if you are making a limited will to say, I give my property in Taikoo Shing to my wife, absolutely, and I appoint her as the sole executor or executrix, full stop. Then this is a valid will, and this is a universal legatee or devisee. So even though I make an absolute appointment of executor, even though I have made no appointment of trustee, well, one does expect, in reality, the risk is minimal or no risk, because I make an absolute gift to someone who is of age or majority. No minority, no life interest, So absolute gift, no problem. Sometimes the situation may be different. If I make a will, I give all my estate to my son, who is now already 14-year-old, and I appoint him as the sole executor. Then in situation like this, or even in the earlier example which I've just shared with you, meaning I give all my estate to my wife, absolutely, it's always preferable to appoint him or her as the executor and trustee of this my will. Then this is much safer. So the safe provision is only in respect of appointing the same person in two capacities. So either in one capacity as executor, or in dual capacities as executor and trustee. So in a situation like this, no risk. I appoint the executor as executor and trustee. It doesn't matter if there is no trust arise. Executor himself will give him the authority to deal with the estate. So no problem. It's just a surplus or excessive power. It's just that the excessive power need not be used. So you make a will, you appoint, give everything a universal legatee, and then appoint him or her as the executor and trustee of this will. That is usual and safe. Then there are other terms for us to consider in our practice in grant. One of the executors or executors, item 2 or item 3. I make a will, I appoint more than one executors, and then when I die, not all the nominated or not all the named executors under my will proceed to apply for a grant of probate for various reasons. One of them may be overseas, finding inconvenient to come back to Hong Kong. The other may be under the age of 21 years, not eligible to apply. And there may be situations that some of the executors have died already, or they have renounced. So all this will give rise to the possibility that even though that you have mentioned or named more than one executors, not all the named executors will apply for probate. In a situation like this, the probate will include suitable wordings to deal with the situation like that. I appoint A, B in my will. I die. Only A apply for a grant of probate. That in the probate, power will be reserved to B to apply for a double probate. So probate granted to A with power reserved to B to apply for a double probate when the need should subsequently arise. So the probate was only granted to one of the executors. Alternatively, if I appoint A and B, B died before the testator, then probate will be granted only to A, one of the executors named in the will, and the probate will contain wordings to the effect that B have died before the testator. So no power will be reserved for B to come in. if one knows the death of E already. Then there comes the more difficult point. Item 3, no problem. There is no law that says only one executor can apply for probate. Now, in the will, I can name Mr. Wong as the testator. I can name all the students in this class as my executors. This is still a valid will. This is still a valid appointment. So I have 40. I have 40 executors. But then in a while, you know, probate registry will allow a maximum of no more than 4 executors for probate to be granted. The question was, or the question is, on the other side, is there any minimum number of executors? This is a question that needs to be considered carefully, and I'll explain that later. For the moment, just remember, is the maximum number that will restrict the number to 4, and there is no minimum number in terms of executors. I may appoint in my will A, B as the executors of my will, like item 3. I may also appoint C, D as the executors jointly and severally. Item 3 and item 4 are valid appointment. The difference is, in item 3, A may apply for probate, B may apply for probate, A, B together may apply for probate. This is item 3. On item 4, I appoint C and D as the executor jointly and severally. In a situation like that, the probate registry will require the application to be made by both of them without any power to be reserved by another one to come in. So the safest appointment clause is item 3. It gives the safest provision and the best of flexibility. Item 5 is the worst one. Item 5 is the worst. I appoint E and F as the executors jointly or severally. This is an appointment which must not be made, because the present practice of the probate registry were to treat item 5 as unclear appointment, confusing appointment, and therefore as an invalid and void appointment. You guys will have to be extremely careful if you are acting as a conveyancing clerk, because there is a distinct difference between the making of a power of attorney, that you can say something jointly or severally, or jointly and severally. This is still valid. But in making of a will, item 5 is definitely void, invalid. So, the best bet will be either item 3 or item 6. Item 3 or item 6. Depends on your wording. And leave the rest behind. The probate registry was at one time earlier this year trying to loosen or to give more flexibility for item 5. But then after discussing with the Law Society, eventually the probate registry agreed that item 5 remains very problematic, and therefore they continue to take it as an invalid appointment. The thing that will arise in the item 5 situation is when we have a named executor, as it turned out to be an invalid appointment, then what is the effect of such? So we got several similar scenarios. We may have an invalid appointment of executors. We may have an invalid of disposition of all the gifts in the will. But then ultimately in these two scenarios, the will remains valid. In the first scenario, there is an invalid appointment of executors, meaning there is no valid appointment of executor. So your question is it a Rule 19 application or a Rule 21 application? If this is a Rule 19 application, what is the highest priority? And who has the highest priority? So that will be something for us to consider. Then in terms of an avoidance of gift affected by the doctrine of left, you still have a valid will. But the problem is the other way around. You have a valid will, you may have a valid appointment of executor, but then you don't have a valid testamentary disposition. So what you have is the skeleton of a will, you have a valid appointment of executor, you have no one to give as a beneficiary under the will. So that gives rise to a partial intestacy. Partial intestacy in the second scenario that we have just discussed is partial intestate in the sense that there's a valid appointment and probate will be granted. Executor, however, will not be able to effect any gift under the will, and then there is the disposition to follow the rule of intestacy under Cap 73. All this, on the one hand, affects of the testamentary disposition. On the other hand, will have an impact on grant priority application. So all this will be particular acute in terms of the problem when it is a kind of informal will. I have recently come across a will which is made by a qualified lay client, well qualified, but they are, well, I would say, good consumers. They make sure that the money is not being wasted. So they have good education, they have good command of English, and then they have good resources like you guys. You can get the resources online. So what this guy has done, he goes online, gets a very good precedent, download, change the names, change the ID card number, and then actually sign it. So we have the signature of the testator, we have the signature of two attesting witnesses, properly dated, a perfectly valid will, costing not a dime, totally free of charge, at their own command. The only thing that they spend is the piece of A4 paper. That's it. Unfortunately, a will like this is too late to regret. You never know. You study with Mr. Wong, one of the best probate lawyers in town, then you must be a good student, right? You never miss a class. You make a will like this, you can copy my PowerPoint. Yet, this is something you cannot take regret, and regret always comes only too late. Because you cannot ask the testator to come back and make another will again. He's now already in hell. But that is exactly the situation. In the example that I've just quoted to you, they have been very careful to make sure that the named beneficiaries will not attest the will. The problem that they have made, they asked the spouse to be the witnesses. So we have a testator, 3 siblings, testator 1 sibling, make a gift to 2 other siblings. Very good, free of charge. All right, sign it. Ask the sisters-in-law to sign it as witnesses. They feel that this is watertight, entirely free of problem. Only then the testator die. When they pick up the will, carefully pick it down, and then they look at it. They know that the will is void. The will is not void, but the gift is void. I'm sure when they make wills again, they will never make this mistake again. But then who knows? You guys will make the same mistake. So always remember, a doctor should never treat himself as a patient. These are money that needs to be spent. You have to borrow your eyes of your learned colleagues. Go and get your student. You guys are in the professional stream, all these classmates are probably working in legal firms. Ask your students to make a will. Okay? You don't pay 10,000, at least you pay 1,000 now. Okay? You don't pay them in cash, you pay the red wine now. Still, this is something that must be very careful. All through my practice, I've seen various silly mistakes. I wouldn't say silly, it's just careless. It's only the repercussion is so huge and regrettable. You've got all the professional knowledge, and now you end up making such a fuss. Okay? Age requirement in will, no age restriction. So you can make a will for a testator, appoint his 2-year-old son as the executor. It is still valid. There is no limitation at all. Except that now, you have to wait to make a grant. You never expect you're going to die so soon. All right? Then by the time when you make the grant application after you have died, then the named executor, your son, will have to be 21-year-old or more in order to be eligible to make a grant application. Okay, let's take a break now.